Hello, thank you for joining us. Welcome from me, Michael Scott in the UK, and from my joint convener, Sanford J. Ungar in Washington, DC, to this, the 54th jointly promoted event between the Future of the Humanities Project and the Free Speech Project. The latter is sponsored by Georgetown University and the former by Georgetown's Humanities Initiative in association with Campion Hall, Oxford, and the Las Casas Institute for Social Justice, Blackfriars Hall, Oxford. Together, the two projects consider issues concerning human dignity, rights, cultures, histories, traditions, and freedom in a wide spectrum of educational activity, policy, expression, and aspiration. In a moment, I'll hand over to Sandy, who is the director of the Free Speech Project. He will introduce today's distinguished guests and moderate the ensuing discussion before I return to chair the question and answer session. From the start, you can type in questions to the panel by using the Q&A button at the bottom of your screen. Please use the Q&A button, not the chat button. These will come to me during the session, and I will try to put them to the panel for consideration. We urge you to ask questions as and when they occur to you so that we don't fall out of time at the end. With that, over to you, Sandy.
Thank you very much, Mike. We have a wonderful panel lined up today, one member of which is still not online with us. We're not entirely sure why, but we're going ahead on schedule anyway. To introduce people briefly, Thomas Berry is a young scholar at the Cato Institute in Washington, D.C., a center of libertarianism known around the United States and around the world for its influence on various positions. He's a former federal appeals court clerk, and his special areas of interest include the separation of powers, which is one of the things that we are talking about today, the key thing we're talking about today. We also have back with us, by popular demand, Baroness Mary Gowdy, a Labour member of the British House of Lords, who was, here we are in the 54th program. I think she was with us on program number 2 or 3 for the first time. And she advocates for women and children's rights, gender equality, and peace building. And she's an advisor to the Institute for Women, Peace, and Security at Georgetown University, and sits on the advisory board of my alma mater, the London School of Economics. Clyde Graham is the principal and chief executive officer of FG Solicitors, an award-winning United Kingdom law firm that he founded in 2007. And he has been with us previously as well, and offered us wise comment on matters of controversy and concern. I'm told that Fernanda Nicola has now joined us. There she is. She is professor of law at the American University Washington College of Law, where she directs the program on international organizations, law, and development. She's very knowledgeable on matters in the European Union, and has won prizes and given distinguished lectures at Harvard Law School, among other places. So I'd like to begin with Mary Gowdy, if I may, and ask Mary, we're quite worked up on, you want to unmute yourself, Mary, one of the less attractive words in the English language, unmute. But we're quite worked up in the United States about the separation of powers crisis that many believe we have here, where the executive is acting on his own and thus far supported by Congress up to a point, but the courts have tried to slow things down. And really what I want to ask you is whether this is a unique phenomenon in the United States right now, or this is something that is being worried about or focused on in a widespread manner around Western democracies?
Taking the United Kingdom to start with, the Prime Minister has to go to the Cabinet, which is all of the Cabinet are elected members of Parliament and are chosen by the Prime Minister in conjunction with other members of Parliament. So, and also before any major decision is made, besides the Prime Minister taking it to Cabinet, if it's very serious, it also has to go to the House of Commons. And if it wasn't to go, the Speaker can insist that it comes back to the Commons. And from the Commons, it has to be agreed with or scrutinised by the House of Lords, even if we have to do it in a couple of hours. So those are the markers. And then if people are unhappy, you can then go to the Supreme Court or one of the other courts for judicial review. So there's quite a process before.
Yes, and is that process being circumvented or questioned very
No,
widely in other countries?
I think in other countries, but not with us. The only time that it gets really present in our country is that we have one or two people who don't believe, just think you should get on with it. But that's not of the left, that's of the right. That don't like that. But I know that in other countries, and I think Fernanda can say more about, I know about Europe, but she knows much more than I do.
Yes, Fernanda, I'd like to turn to you now. Make sure you unmute yourself.
Sure.
Interested in your thoughts about how the European Union is reacting to this international brouhaha.
Well, let me say that though with Brexit, we saw that even in England, enemies of the people was something that was portrayed by the Brexiteers as, having judges pushing back against an act of parliament simply, pushing back against the government or just a referendum deciding over the exit of the UK without a full act of parliament. So I think that started the rhetoric of judges being enemies of the people. But I was just talking to a colleague about this, how in the US this idea of not challenging the rule of law is not widespread, as we've seen recently in Hungary and Poland, but where not only we have countries where there has been a real attack by the government against the judiciary, there has been a very active role of the European judiciary, especially in Poland, to push back. Of course, the European judiciary was mobilized by local constituencies in Poland, and so local judges, they were demoted, lawyers were prosecuted, etc., brought cases before the European Court of Justice. And in this scenario, kind of supranational scenario of the European Court of Justice of the EU that has 27 member states, no longer the UK, sadly, but the idea was that the Court of Justice took this kind of type of jurisdiction overseeing also the judicial independence of domestic courts, which seems going beyond its competence, because with the reasoning, which was put out in a case on the Portuguese judges back in 2019, with the reasoning that even the courts of the member states cannot go rogue, because that will undermine the whole judicial architecture of the union. So it's not a whole internal situation, it's a European situation, and the EU is based on mutual trust when it comes to judicial cooperation. And therefore, if one country goes rogue, so many systems of the EU, the asylum system, the European warrant system, where you exchange prisoners and people who are criminally convicted from one jurisdiction to the other automatically, all those systems will be undermined. Therefore, there's been, in the case of Poland, now in Hungary, etc., a very, very
If I may interrupt you for just a moment. In Poland, the situation that has gained a great deal of international attention is that the judges themselves became activists on a political level. They went around the country giving lectures to explain what was important, and they prevailed.
Absolutely. There was a march.
Uh,
They did marches. They really mobilized with, as you said, the judiciary, with basically lots of references at also the European Court of Human Rights, where there's kind of easier the access, but also before the European Court of Justice. And then they also though marched and activated the
Right.
in various ways. They created coalitions with feminist advocates, like
Right. Well,
reproductive rights advocates, with anti-corruption and pro-immigrants lawyers. So
we'll be back to you in a few moments to talk about the situation in Italy. But first, I want to ask Tommy
Just-
Berry.
Sorry, Sam, just can I just say one point? Sorry, just to say that Britain is still a member of the Court of Human Rights. And we won't talk about that now, but there are some people in our country that would love us to withdraw from that. And we've had great arguments, but we are staying. And certainly this government wants to stay. And we've had some great wins, including one the other day.
Well, that's very useful information to have. Thank you, Mary. Tommy Berry, can you conceive of a situation in which the federal judges or perhaps local judges would become a political force in their own right, march, lecture, lobby the way they did in Poland? Is my first question to you, and then I have a broader one.
Yeah, it's an interesting question. So a norm has developed in the United States that judges can lobby, can advocate on political issues with respect to the organization of the courts. So if you have a question, for example, about should the appellate court system be reorganized? We have one very large appellate court called the Ninth Circuit that's on the West Coast that's about twice as big as every other. Every year there's controversy, should it be split into two? And judges on that court will go to Congress and make their views known. Do they agree with it or not? Similarly, questions about should we increase the number of judgeships at the district or at the trial level or at the appellate level? They'll make their views known. Should we, for example, there was a bill passed a couple years ago that created more judicial privacy measures that essentially allowed federal judges to censor things like their home address, their spouse's workplace, etc., supposedly for the sake of personal safety, and federal judges explicitly lobbied for that. So when it's something related to the organization or rules for the judicial workplace or judicial system, I think their view is that that's within the bounds of their expertise. But beyond that, the norm and in fact the code of judicial ethics is that they don't get involved. There was a pretty infamous incident where then Justice Ruth Bader Ginsburg, who's since passed away, did an interview during the 2016 presidential campaign where she called Donald Trump a faker. And pretty mild stuff for most people, but the fact that she was a judge caused a huge outcry to the point where she essentially had to apologize and retract that. So there's an interesting split in the United States that judges are very much thought they should stay within their own domain. And I think that comes from a notion of separation of powers, that the legislature and the presidency are supposed to be the political policy-making branches, not the judiciary.
Well, speaking of the separation of powers, do you share the view of so many people? There's a crisis right now in this country for the separation of powers that President Trump is moving ahead very very definitively on some matters. Some say he's ruling or attempting to rule by decree rather than by act of Congress. And do you share the concern over that?
I do, though I'd stress he's certainly not the first president to take these actions, though I think everyone has, to some extent, it has been constantly building. And I think absolutely there are many factors that have come together to allow us to reach this crisis point. And you can put some blame on both of the other two branches. You can put a lot of blame on Congress for not passing enough laws and passing laws that are too vague and give too much discretion to the executive branch. So part of the increased power of the president comes from that leeway he's been given.
Good point.
And part of it I would also put on the judicial branch. In 1935, the Supreme Court struck down two pieces of legislation for being too vague, for essentially abdicating the policymaking role to the executive branch. But for 90 years since, they haven't struck down a single law for being too broad and too vague. And I think that that's a problem, and we need to get back to the judiciary policing those bounds. But you can also put a lot of blame on the executive branch, even with the vague laws that have been passed. I think some of President Trump's actions have exceeded his statutory authority. And when it does so, it's the court's role to put a stop to that. They necessarily move slower than the executive branch, but we shouldn't lose hope that eventually they'll catch up to it, because there are, I think, over 170 lawsuits in progress right now challenging Trump's actions.
Wow, that's quite a few. Floyd Graham, a part of the ongoing crisis in the United States right now is that law firms that have brought some of these actions, some of these 170 actions that Tommy Berry describes, have been pressured by the president and his people to accept agreements to, some would say, soften their posture, their activity to spend money on things that this president supports, to back him up and so on. And there's a major split among the largest law firms in this country as to whether to cooperate with the president or not. Could that ever happen in the UK, that sort of thing? Floyd, I can't see, but you may be on mute.
I'm so sorry. Nobody, unless we had an extremely right-wing government, and even then, I don't think that they would try to interfere with the law firms. They complain about lefty lawyers all the time. That's a constant theme of them, but they would not interfere, because at times they need to go to them for advice. So it's but they would not. What's happened, but at the same time, the president has written to British law firms that are international, saying we don't want you to do this, that, and the other. In the same way, he's written to corporates who believe in diversity and other issues. He's written directly to them and to those companies who have American contracts.
Floyd Graham, I think you're off mute now, and you could.
Yes, thank you, Chair. I was slightly taken by the question about whether Western democracies can preserve an independent judiciary. And I think there's a presumption that there is an independent judiciary in the first place. I wonder whether the real question is whether Western democracies can truly achieve an independent judiciary, because in the UK, we are blessed with an unwritten constitution, but we do have the separation of powers. And as Baroness Goody rightly pointed out, that there is always the option of judicial review, where the executive engages in quasi-judicial actions, and it is therefore right for the judiciary to intervene, both at a first instance level with the decisions and also at the appellate level. I think in terms of interference with law firms, that's highly unlikely to happen in the UK. Speaking for myself as the leader of an international law firm, but one that's based in the United Kingdom, it would have the opposite effect if President Trump or anybody else tried to influence our ability to act in the best interests of our clients. And that is that's the mandate and focus that we would follow. So my opinion, although I don't pretend to speak for all law firms, I think it's reasonable to conclude that that would be a very difficult thing for an external to do.
What, if I may be slightly presumptuous on your behalf, what would be your advice to the American law firms who are so embroiled in this question at the moment?
I suppose my advice would be to put the interests of their clients first and foremost, beyond any external influence. We took an oath as lawyers to uphold the rule of law, and we took an oath to put our clients' case in the best way we can, to the best of our ability. And that shouldn't be easily interfered with, nor should we accept it.
Nicole Fernandez, sorry. I wonder if you could tell us, I have two questions for you in turn. First of all, give us a brief look inside the Italian side of this crisis and what's happening there. And then I'd like you to speak briefly about what you perceive as the attitude of students on some of these questions, law students in the United States at this time.
Both are great questions. So the first one, the Italian situation, let me say it's a bit complex because it's very intertwined with the issue of migration, which is not that dissimilar from what's happening here with the judge blocking the plane going to El Salvador. So it's a very similar scenario whereby, as you know, Prime Minister Meloni has tried to create these kind of bypassing of European immigration rules based on these Dublin III conventions, which burdens heavily countries of the first arrivals of the migrants, such as Italy and Greece. Therefore, she tried to create this kind of agreement or deal with Albania. The deal was even praised by von der Leyen. The EU has done something very similarly, not to be praised, but with Turkey, trying to send migrants to Turkey before processing them or having them removed from Greece and sent to Turkey. So it wasn't something outrageous until when the migrants arrived to the coast of Italy last fall and were sent to Albania. Several courts throughout Italy started to block these kind of removals, said that these migrants should have a fair review of their asylum rights, and the Albanian removal was just a shortcut. So we had a similar situation, kind of what happened here more recently with the case of the Venezuelan immigrants. What happened, all these courts start blocking and going after the Meloni government for these decisions. And right now, tomorrow, we have a decision of a first opinion of the Advocate General of the European Court of Justice over exactly these cases. Why the cases went to Luxembourg? Because many of these courts, Italian courts that were blocking this removal of the migrants and be sent to Albania, were doing so on the definition of whether the countries where the migrants were going, in many cases Bangladesh, Nigeria, was a safe country. And so the question now that is being posed to the European Court of Justice is whether this definition of safe country can be a definition that the Meloni government, the Italian government, can decide with a decree, as opposed to a decision made by the European Union. And also on whether, on that definition of safe country, that of course the Italian government says, we want to have a list, a very broad list of safe countries. And as I told you, basically, Egypt is very safe for LGBTQ people. The question is whether the Italian judge can disapply the Italian application and say, sorry, Egypt for an LGBTQ person is not safe for that particular person because they are not welcome and they're going to be prosecuted in that country. So the question now before the European Court of Justice is whether an individual judge can defer and disapply the notion of safe country by the Meloni government based on evidence or not. And the Court of Justice will decide on this case. The Italian government has already argued the case last February before the court in Luxembourg, saying that according to them, that decision, it's a decision can only be taken by the Italian Constitutional Court and not by an ordinary judge. And that goes against the European law that says that any ordinary judge, whether they see that it's relevant to disapply Italian law or domestic law because of protecting fundamental rights, they should do so. So since the creation of the Treaty of Rome and a decision of 1960 called Bang de Luz, there's been this empowerment of the national judge to implement EU law when it's deemed relevant and necessary, and disapply the Italian law, something that also in the UK happened after they joined with the.
I'll pause just for a second before I ask you to answer the other question to say that this would be a good time for our remote participants to put their questions into the Q&A link at the bottom of their screens. But what is your impression, and this can only be an impression, I think, about how law students are reacting? Are they thinking maybe they should have gone to medical school instead? Or?
Oh, we have a boom of applications. I think students want to be on the right side of history, and they want to also, they think that living under the rule of law is certainly better than living without the rule of law. For their future, for their present. I just want to say one last thing about the Italian situation and also for our students. First of all, our students see the parallels. So at American, we have lots of international students. Many of them have been writing about migration, rule of law, and of course, it's obvious that the US government and the Italian governments are very keen to, as we said, expand this notion of safe countries for their own benefit, but also this idea that the government can interfere and change the sort of judicial architecture, and the judicial is something that the Italian government is also pushing to revise the constitution and try to change the kind of the independence of the judiciary, especially for the prosecutorial branch. They are also trying to create a disciplinary chamber that will be controlled partly also by the government through the parliament to make sure that the judiciary will be more under control of the parliament and the executive branch. So our students, I think we have a boom of applications. Last night, I just finished teaching my European Union law class. Many of them are studying of course, the law of the US and the changing laws, but I think they're even more interested in other countries where the rule of law has been under attack for years. Poland, Hungary, Italy in many ways. Austria was one of the first countries where the famous procedure of Article 7, which is the potential suspension of voting rights in the Union, was initiated against the Austrian government. So I think seeing that the US is now leaving something that other countries have experienced already, Poland has managed with an election to kind of change its trajectory, but it's something very useful to our students to see what are the forms of resistance, upholding the rule of law, where does it happen, and how they can react.
Thank you. Tommy Berry, I have a couple of questions for you that I think are important, and you'll need to unmute yourself. We have a system that you described very, very precisely and accurately, but some people are a bit cynical about the composition of the Supreme Court at the moment and whether some of these disputes will be fairly reviewed at the Supreme Court level. I'd like to ask your thoughts about that, and then I want to ask you a question about the state courts, but let me ask you to talk about the Supreme Court first.
Well, I would say I think that cynicism is overblown. I would look to in Trump's first term, 4 to 8 years ago, several of his actions were struck down by the court. Even it had a majority conservative makeup. Even then, his attempt to add a citizenship question to the census, for example, was struck down. And I would say that. There are two ways these cases can get up to the Supreme Court. One is on the so-called emergency docket, or some people call it the shadow docket, where the court has to act very quickly just to kind of decide what the status quo is, or because people say it's an emergency or something might be irretrievable unless they act immediately. And I would say at that posture where they haven't had full briefing, it is more likely that justices will kind of fall back on their priors, one might say, or their gut instincts about which is right. And you do tend to see them break down more commonly along conservative versus progressive lines in that posture. When a case has been fully argued and the justices have their normal 2 to 3 months to write the opinion, you'll usually see at least a couple justices, often more than you might think, fall not with their what you might consider traditional faction based on the party that appointed them. I think a lot of these cases really do come down to the specifics. Does a particular statute authorize a particular action? I think Justice Barrett, for example, has written a lot of interesting and nuanced opinions in the last several years where she's joined her conservative colleagues in part, but also not gone as far as they were willing to go. So I would say, take it case by case. And also a lot of the principles that the conservative court said over the last 4 years, things like the so-called major questions doctrine, which says that when a president finds a new power, a vast new power in an old statute, we should be very skeptical. Those principles are now going to be very useful to people challenging the Trump administration, and I expect the court to apply it consistently.
There was quite a controversy over the election of a member to the Wisconsin Supreme Court, I think just last week. And it was the most expensive, certainly the most expensive judicial election, perhaps the most expensive election period in American history. And Elon Musk, for one, put in a vast amount of money to that election, and his side lost. Do you is that a perversion of the judicial system? Do you think that judges should be elected in this partisan way, or should return to a system which was more prevalent before, of nomination of justices in a kind of bipartisan or nonpartisan way by wise committees or councils or people who take the larger issues under consideration?
I prefer the way we do it at the federal level and the way many states do it, which is where judges and justices are appointed rather than elected for a few reasons. One, I think just forcing them to go through this campaign procedure will tend to weed out a lot of people that I think have the best judicial temperaments because they're just not interested in going through that gauntlet of a campaign. That sort of test, that gauntlet to get on the court is the type of thing someone with more of a political mindset or attitude would be inclined to go through rather than someone with kind of a introverted judicial mindset. I would say it's tricky, how we put people on any court is a tricky question of democracy because you don't want it to just be outcome oriented. The point we want the public to understand that the way we decide judicial cases is different from the way we decide political questions, like should we vote for or against a bill. We're not putting judges or justices on a court to get a certain outcome. We're putting them on the court so that they can follow a legal process. But judges and justices do legitimately have different approaches to interpreting the law. And I think it is legitimate for there to be a public debate about those approaches, whether it's just based on the original text and original public meaning, or whether they should take into account other factors such as, practicality, best outcomes, intent of the legislature, and so on. So I think it's legitimate to have that broad debate, but I think it's better if it's a little abstracted, that the political parties can, in general, say what their philosophy philosophy is what type of judges they'll be looking for, but you don't have the judges themselves running in a way that makes it look a lot like a political campaign and look like they're no real different from legislators.
Right. Floyd, do you think that the ongoing controversies over the powers of courts or the role of courts has made the role of the law or the study of the law less attractive in some ways in the UK? In a sense, the same question I was asking Fernanda a short time ago about this country is how is that reflecting on the study of law in the UK?
I don't think it undermines it in any way. I think it creates a deeper interest in understanding the mechanisms that allow the law to operate effectively. I think if you take the UK, for instance, where the law comprises of statute, which is determined by Parliament, and you also have the common law, and you have the law's ability to apply the concepts of natural justice as an overarching interpretory instrument. The interrelationship between those various aspects of UK law is something that is of great interest to most law students. And in my spare time, I'm fortunate enough to do guest lecturing for one of the universities in the UK, and just looked at statistically, the numbers are increasing. Rumors of it being a sure signpost to wealth, untold wealth, is overstated, I think. But beyond that, I think the interest in the law it remains a healthy one, and I can't see that changing anytime soon. I think the courts still have the ability to look at not so much what Parliament has said in a statute, but what Parliament meant in the drafting. And so the interpretive powers that the judges still have, and the various levels of the judiciary still have, is quite a powerful instrument. I don't know enough about the American system to draw any direct comparisons with any integrity, so I'll abstain from that. But to the naked eye, they don't seem to be bound by the same abilities or that exist in the UK legislature, and the role that judges play in interpretation. In the common law arena, then I think judges have far wider powers of applying the law to the facts and creating the right ratios, and their obiter dicta statements are quite powerful tools where they feel constrained in some way by political influences. So I think in the UK, preserving an independent judiciary is in a healthy state. That would be my view.
Mary Gowdy, can I ask you to cast your view toward Europe? For example, the situation in France has not yet been mentioned, and the restraints that were put on Marine Le Pen by the courts, and some people have questioned those. And then there's the somewhat notorious case where your former Prime Minister, Rishi Sunak, wanted to send unwanted immigrants to Rwanda, and that was blocked. So there has been no absence of controversy involving the courts there. Be sure to unmute, please. And could you just give us your overview of these matters?
Yes. On the case of Prime Minister Sunak, is that there was a huge opposition, both in Parliament and in the House of Lords to sending people to Rwanda, which is not a safe country, as we know, and at that time it's less safe now, but at that time it was unsafe, and paying funds to Rwanda, which had already been done in advance, and by going to the court, by taking the case to the court, there was an overall, including the country, majority for this not to happen, and including NGOs, you name it. There was a huge swell. In the case of France, I think that it was the right decision, but I don't know enough about French law. And I did say, which I don't know whether it's true or not, that magistrates also came out and demonstrated, quite understandably, but at the same time, judges used to demonstrate in this country, I do know, but I don't know which judges still demonstrate. But there was a time during the Vietnam War, I can tell, against the Vietnam War, there was a few judges and others who would come on the demonstrations to check that there was no impropriety by the police, because we were having problems with the police at that time treating demonstrators.
So the judges actually came to the site of the demonstrations to make
check
sure the police were not misbehaving.
That's right. It was also organized by Liberty and by Civil Liberties at that time, which was in the 70s. That hasn't ever happened since. We've had demonstrations, but they've also been much more peaceful, and you don't have policemen coming on police horses. And that was one of the things, that doesn't happen anymore. If it's a demonstration, you've just got police around in a peaceful way. All of that's changed. And in the question of France, I don't know whether it's true or not. And Fernando and Floyd may know whether magistrates did go to demonstrate against the movement there and Marine Le Pen. That I hadn't read about until starting to look up stuff for today's conference. So I'm still not quite sure whether that was true or not. But I think legally, if she did what she did, then you shouldn't be allowed to stand for office. In the same way, in this country, if you did something like that as a politician, you wouldn't be allowed to stand, or you'd be suspended for a period before you could stand again.
Well, there certainly were serious charges. There were certainly serious charges against her of embezzling funds from the European Parliament for her own electoral benefit in France. That seems pretty stark. We're getting very close to when we want to go back to Mike Scott and have him pose the questions that are coming in from listeners. But I want to go back to the two participants who are on American soil at the moment, Tommy Berry and Fernanda, to ask them briefly for a little bit of a crystal ball look at how is this going to turn out for the judiciary in the United States if things continue sort of along the current path. 170 challenges the president's action are quite a few to deal with, and some of the preliminary things, as Tom was talking on the shadow docket, have been decided, at least provisionally, in the president's favor. But how do you see all this playing out? Tommy, why don't we go to you first, and then right after that, Fernanda.
Sure. So I think one thing I'd emphasize for court watchers is that even though it may seem like it's been an eternity since Trump was inaugurated, it's actually quite early. And for the courts, we're extremely early. Courts move at a pretty glacial speed by design. They're contemplative. They want to give both parties enough time to file their briefs and so on. So it could be years. These cases that were filed on day one of the Trump administration, it could literally be 1 to 2 years before we potentially get a definitive answer from the Supreme Court on them. So I'd caution watchers of the judicial system in general to have some patience and not assume just because there are some early losses that the courts have been overwhelmed and Trump is running roughshod over everything. I do think there's a possibility that some long-term changes to the court system could come out of it. One of the biggest controversies in the United States system is the so-called nationwide injunction by a single federal district court. This is something that's essentially always unpopular with whichever party is currently in power in the White House, because it allows a single district judge to essentially stop a policy nationwide. And I think there are some legitimate, again, putting aside who's in the White House, there are some legitimate criticisms that say this kind of forces a rush to the courthouse, a rush to see who can win a case first, and then it kind of stops the percolation of this issue in other courts. It essentially forces an appellate procedure to go up right away and forces it to go straight up to the Supreme Court with fewer district court opinions than we would otherwise have if that district court just decided the issue for the parties in that particular case or for people within that particular district or particular appellate circuit. So it's possible that given all the criticism of it, we might actually have a change in this. Either Congress or the Supreme Court could possibly reach a point where they rein in the authority of nationwide injunctions. That could be one long-term consequence of this. I think similarly, we might have reforms to the shadow docket. A lot of people have said, that we should either change the norms for when the Supreme Court steps in, or otherwise put more transparency, force everyone to publicly reveal their votes on the Supreme Court for every shadow docket case, which they don't currently do. So again, the more we have these emergency decisions, the more momentum might come behind that type of reform as well. So these are things that will take years to see, what long-term changes or reforms might be germinating at this point based on how the court handles this huge influx of cases.
Right. Okay. Thank you very much. And Fernanda, just briefly.
Yes, I
how do you
wanted
feel?
to talk about how the personalization of the judges it's something that is important. We need to know who the judges are, but it can be also very dangerous in the way that a president goes after a judge, or in the Parisian case, the Marine Le Pen, the 3 judges of the Paris tribunals, we don't know who they are, and that somehow protects them a bit. But certainly we saw already Orban putting out his campaign, Je suis Marine Le Pen, and the criticism of this decision, which Macron said, there is an appeal. So the same way in the US, I think it was very important. Justice Roberts is not an outspoken person when it comes to the press, but the fact that he stood up and said to President Trump, no, you cannot impeach the judges. There is an appeal. Same thing in France. There is an appeal. The appeal has been sped up also for Marine Le Pen. So that will be decided before she can present herself at the presidential election in 2027. So same thing. There is justice and the rule of law have their procedures. You have to respect them, and wanted to circumvent by intimidating judges or saying we need to impeach them when there is an appeal. And same thing even for Amy Coney Barrett, who was kind of targeted after the decision of the Supreme Court through the shadow docket to say you have to restate the funds that were suspended by the Trump executive order to USAID and the State Department. In those cases, I think it's very, very dangerous to go after personalized attack against the judges, as we started this whole discussion, and we really need to be conscious that the rule of law is there. There is a balance, and there's appeal.
Okay. Well, thank you very much, Mike. You have some questions perhaps from the remote audience, and we'll move to them now.
Thank you. I'm just getting my video on. Thank you very much. This is a complex discussion. Paul Williams has written in, quoting a recent Lord Sumpton Reith lecture in the UK, and he asks whether the courts should, and he puts that in capitals, should be necessarily independent of government. Are there not times, he asks, when the law has expanded into areas which are rightly the domain of politics? I'll put it to each of you, really. Floyd, do you want to have a go first? You need to unmute.
Floyd, you have to unmute. There
Can
Is
you
it?
hear me now? Yeah.
Yeah.
Right. Well, I don't believe as a practicing lawyer that there should ever be a point where the judiciary becomes so entangled with political considerations that it can't act as an effective safeguard to abuses of power. I think most judges have a sensible understanding of what is happening in the political environment and what is happening socially and how that impacts on citizens of the United Kingdom. But I think that's a different aspect to whether judges should become so entangled with the legislature that there is no true independence, because that would really compromise its ability to act as an effective safeguard for its citizens, which I think is the primary purpose of judges.
Thank you. Fernanda.
I just want to put on the table the idea of judicial discretion, which is not political, but it's a leeway that judges have in interpreting the law, which might reflect or might seem to reflect their political considerations, which are of course embedded in how you interpret the law, but that's how the legal system is built. Judicial discretion is something that judges should have, reason, explain it, and in the judges in the Paris Tribunal for Marine Le Pen, they did an incredible work putting out this idea of democratic public order that it's been criticized now, but they really have to justify through the judicial discretion, whatever they decide, for showing that it's not only driven by politics, but by legal reasoning and interpretation.
There seems to be, Mike, some
Okay.
interesting parallels to be drawn between Marie Le Pen and what happened in the United States with the current president, for instance, and the charges he faced prior to being elected as president, and whether judges were swayed at all by the immense popularity and to put him back in the White House,
Absolutely. It's Trump versus Anderson that went the opposite way. If you look at that case, even though the charges of insurrection of the 14th Amendment didn't apply, but the court was united in that, which was very interesting. The Supreme Court.
Mary.
I think I'd like to say that Jonathan Sumption has now retired, but he does write and is asked a number of times to be on television and give lectures, and is quite a controversial figure, but an interesting figure in the way he puts out the answers. But I agree with Floyd that the judges here would take certainly a different matter, but they also look on if somebody committed a criminal offence, it would be seen as a criminal offence, and they would have to be proved guilty or not guilty in the whole issue. And those, in some cases, would be cases with a jury, and some would not. But I still think here that we do have a fine line between the judiciary and the government and Parliament itself. And that we do have the right to go to the judiciary, as Floyd was talking about before, and I mentioned, with judicial review. And some people would like to see judicial review stopped, but that's not going to happen. And the other way that we have of checking things out, which is not quite for this discussion today, is the freedom of information questions, which I don't think you have in the States either, which was brought in by the Blair government, so that people from outside or newspapers or individuals can ask particular questions under the Act, Freedom of Information.
Mary, we do have a very strong Freedom of Information Act since the late 1960s, but it has been weakened somewhat recently.
Thank you.
Tom,
Yeah, I think it's so important to emphasize that what Fernanda said about explaining the reasoning and explaining why the decision was reached on legal grounds rather than policy grounds. So I like to get past the notion of judicial restraint versus, judicial aggrandizement and say that no, the proper role of the judges is judicial engagement, which is simply to look squarely at the constitutional text or the statutory text and not be afraid to strike down a law or an executive action that's inconsistent with it. So properly understood, that isn't giving more power to judges. It's giving power to the Constitution in the American system or to the legislature and the statutes it passed, and putting that power into effect, into force. So we have a lot of rights enshrined in the Constitution, like the First Amendment, freedom of speech, that are in some cases anti-democratic, anti-majoritarian. We've made the long-term decision to bind ourselves, to bind future legislatures, that even if they think it's good policy, you can't sacrifice the freedom of speech to achieve that policy. And judges need to have the courage and the ability to explain when they strike down a law, it's not because they disagree with the policy, it's not because it was for conservative or progressive ends, it's because it's inconsistent with some constitutional right, like the freedom of speech. And when they do that properly, and when the people understand and feel it's legitimate, even if they disagree with the reasoning, when they think it was from legal reasoning, that's what essentially gives the courts their legitimacy. So even though it can seem like they're being bound up with policy matters, when they strike down democratically enacted statutes, even extremely popular ones, it's a different type of question, and it's important to kind of abstract it out. It's not about those individual judges. It's about a constitutional text that might have been enacted 200 years before those judges were born.
fine, thank you very much for the interesting replies to that. Another question comes in about the 4 pillars of democracy: the free election of Parliament, the autonomy of the university, the freedom of the press and media, freedom of speech, which we've been talking about, and the independence of the judiciary. When you're moving into a tyrannical regime, there's evidence about an interference in all 4. Within parliamentary elections, there is interference. There's a crackdown on university research and the type of research and the curriculum and the teaching. And there's a shutdown of press freedom. And there is an assumed responsibility taken of the judiciary by the people concerned. Do you think that's a fair enough description of what's happening, or what happens? Maybe what happened in the 1930s with the Weimar Republic? I don't know. Mary, do you want to have a go at that?
I was just thinking about that. Yeah, the 4 pillars that's what we stand by.
Yeah.
That's really important. And having a non-written constitution for us, but for you have the written constitution. But I think the 4 pillars are absolutely important, and they're about ethics and what the country should stand for, and what judges should stand for, our expectations from them too.
Yes, thank you. Fernanda.
Thank you. Teaching in an American university accredited by the American Bar Association, I really saw firsthand the relevance of the American Bar Association that's been very forceful. It put out various statements by its president talking about the relevance of an independent judiciary, the importance of having lawyers who do their work and upholding the rule of law. And so as professors in a law school, we felt very much under attack with all sorts of things that but we saw also our leadership being very strong, including many deans, including William Traynor, putting out their statement very forcefully. I have to say that I did a lot of work with the ABA also abroad in Poland and in Hungary, and it's very interesting to see that now the situation has flipped, and I am now going to go to the European Parliament to speak about what's happening here. A year ago, I was in Poland supporting them with their rule of law struggle. So it's a very interesting moment, but the legal profession, I think, is one of these pillars. And in the US, where you see that the ABA is the connection between the academia and the legal profession, and it's very strong. And I think this connection is important for the rule of law and democracy. Thank you.
Thank you. Tom.
Yeah, there's a great example. I think judicial independence is still strong in the United States. A great example, just yesterday, a federal district judge that Trump appointed in his first term, Trevor McFadden, struck down Trump's current action trying to exclude the Associated Press from White House press briefings. It said that this violated the First Amendment freedom of speech, punishing them for their speech. And I think this shows the wisdom of the framers of the Constitution in giving judges two crucial protection. Federal judges have life tenure. They can't be fired. They can stay on the court as long as they're alive during good behavior. And salary protection. They can't have their salaries reduced for their entire tenure in office. And we've seen over and over again judges ruling against the very president who appointed them, because the instant they take office in the U.S. system, they owe no loyalty even to the president who appointed them. And I think that that's so crucial. And thus far, that system is holding. I am concerned about the calls to impeach judges. But fortunately, I don't think we're close to a point where that's actually going to happen. The bar is very high in the United States. You need 2/3 of the United States Senate to remove a federal judge from office. Given the state of politics in the U.S., we're not close to that happening. It's unfortunate that there are even calls for it, but everything I've seen is that the judges are confident that they're not going to be punished for ruling against the administration.
Lloyd.
Thank you, Mike. Well, on that question about the 4 pillars, I think we need to be mindful about the law of unintended consequences, because you need healthy minds coming through the system to create the great lawyers and legal minds of the future. And in some ways, when the executive are making decisions socially and politically, these have impacts on universities. For instance, in the UK, we put in place quotas on attracting overseas students. And that limited the funding of universities to operate in the way that they normally would. And in some instances, that's led to the removal of courses that would normally be available to the citizens of the UK to make valid choices. Even in the legal sphere, one looks at administrative and constitutional law now as archaic and out of date, and it's not an exciting prospect for young legal minds that want to look at corporate law and criminal law and every other aspect of our legal system rather than that. So I think we ought to be vigilant to identify and understand the law of unintended consequences, where our government acts in a particular way that has an impact on the very things we're trying to safeguard and protect.
Thanks very much. Another question that's arisen is to do with respect. The question is there a critical issue when one aspect or one area ceases to respect the other, so that when the Parliament or when whoever the government ceases to respect the judiciary, or when the judiciary ceases to respect the government, is that something that occurs, or is it neatly put to one side, the lack of respect from one to the other? Does it have a bearing? Tom?
Yeah, really, really deep question and crucial long term. I think certainly we have a history of a lack of respect, you might say, for the judicial branch from the political branches. This is not new. You can go all the way back to, I mean, as recently as the 1960s, the so-called Earl Warren Supreme Court, when Earl Warren was Chief Justice, made a ton of hugely controversial decisions that put mostly in a progressive direction, decisions that have had a lasting change on American society. And there were calls to impeach Earl Warren at the same time, calls that they were politicians in robes. So not a new trend. And ultimately, it didn't weaken the force of those decisions. There was some so-called massive resistance in the South, especially to things like integration. But ultimately, the legitimacy of the court won out. Those, especially given that President Eisenhower helped to enforce it, brought National Guard down to help enforce those decisions and integrate. So that was an important moment. I think lack of respect coming from the courts to the political branches is less often commented on, but there's definitely an element of that. There were a series of cases about the Affordable Care Act, so-called Obamacare, generally upholding it, but some noted a hint of sort of disdain in the way that opinions were written that kind of said, we should be aware that this law was passed in a slapdash, not very functional manner because it was thrown together at the last minute and they had to make various changes to get the votes and so on and so forth. And some have criticized that and said that the courts should not throw shade on the political branches because it will lead them either to think they're smarter than the political branches, or it will lead them to give less weight than they should to the decision that Congress made, essentially less respect to the political branches. So there could be, I think that point is well taken, that as much as possible, judges should err on the side of not even making their opinions known about the political branches in their opinions. For the best practice is probably to just leave that out and be as down the middle, stick to the facts as they can.
Mary, would you like to comment on that?
I think the judges shouldn't, as individuals, say what their how they lie, but most people know how they lie, not lie, but where they're coming from. At the same time, the general public rely on the judges for fair hearings in against certain legislation, which people know is wrong, and the alternative way to deal with that is to go to the court, to judicial review or similar actions. But that the trust should never be broken between the judiciary and government and parliament. I think that's really important, that there should never ever be a breakdown of that, of those three key things, because that's key to law and order into a country and so on. We should never let that happen. And if that was likely to happen, then we have to somehow mediate that, because that would be wrong. In the same way, we have this problem over we don't see a problem, but the Court of Human Rights, where people try to belittle that and say it's all about chicken nuggets and stuff, which is disgraceful, because it's not. But there is a way of trying to belittle the judiciary and important tribunals, and including the employment tribunals and rent tribunals. All of those are vital to the running of a country and to fairness.
Yes.
And the public have to have the citizens have to have somewhere to go to get rulings on issues.
Yes, thank you for that. Thank you. Floyd, you want to say anything more to that?
Only pretty briefly. We were talking about the consequences of a breakdown in respect on both sides. And in my view, the role of the judiciary is to subject decisions and acts of parliament to judicial scrutiny. And as part of that process, there will be occasions when judges will find the law that's been created via Parliament's actions as jurisprudentially unsound. And in those instances, the judge really ought to make that clear, but in a way that doesn't undermine public confidence in the government of the country. And most judges are pretty good at doing that. Occasionally you get one that strays and unbridled contempt, but that's very unusual.
Thanks for that. Fernanda.
I will just say, I'll go even further back than Tom by saying that Federalist 78, Alexander Hamilton had already prepared us with the least dangerous branch, but yet without the powers of the sword or the purse, yet the power of legal reasoning, which is something that the judiciary should convince people, should also have an eye for what public opinion says, but certainly try to reason and articulate the reasons and convince people about their legal reasoning. And us as academics, especially in law schools, that's what we're trying to do, to convince our students. And I was telling Sanford before, we have now a boom of applications in law schools. They went up 20% because everybody feels like this is our only way to protect what's happening to us. And the idea is to teach and have the academic freedom, protect the academic freedom of tenured professors. I know it's a huge privilege, but this is a moment where academic freedom and being able to say what we want without being fired is something very precious. And so it's something that I cherish, that we have, and we can really speak freely and continue teaching our students about academic freedom and write about it, and continue doing our job. Thank you.
Thank you very much. Sandy, is there anything you want to say as
Well,
we start to wind up now?
As we conclude, Mike, I want to thank everybody. This is such a hot topic in America right now, and it's interesting to see that it has ramifications in other places as well. I want to thank our excellent panel. Mary Gowdy, thank you for coming back to us from your busy agenda at the House of Lords. Tommy Berry, we're glad to meet you and hear your thoughts. Floyd Graham, good to have you again as a member of the bar. And Fernanda, I thank you especially. I know this is a busy moment for you. I just want to note that my son is a graduate of your law school and a prosecutor in Illinois now, and benefited greatly from his education there. So thank you to all the people from Georgetown who support Mike and me in this series, and we're going to keep it going just as long as we're standing.
Thank you, Sandy, as well for chairing it today and for all the work you put into it. The next free speech project at the Crossroads International Dialogues event, in association with the Future of Humanities project, will be on Wednesday, May the 7th at 4 p.m. in the UK, 11 a.m. in DC. And we're going to be discussing fact-checking. The next Cultural Encounters, Books That Have Made a Difference, will be on next Monday, the 14th of April, when Professor John Ford-Rescher from Georgetown University will be discussing Daisy Miller by Henry James. For today, my thanks also to people at Georgetown, particularly Tom Banchoff. Without his support, we wouldn't be able to promote this. At Blackfriars, to Dominic White, the prior, John O'Connor, the regent, Richard Finn, the director of Las Casas Institute, and also thanks to Nick Austin, the master at Campion Hall. A special thanks to John McCabe and colleagues at Georgetown who have made this Zoom event happen. I'd like to thank those who've asked questions and thank you all for attending today and for your support for our various series. My final thanks to my wife, Maggie, who helps with the administration on this side of the Atlantic. I'm Professor Michael Scott, Fellow and Senior Dean at Blackfriars Hall, Oxford. You can follow me on Facebook as Michael Kerr Scott or LinkedIn as Professor Michael Scott. Until next time, take care, keep safe, and panelists, many thanks once again. Thank you all. Bye-bye.
Bye-bye.
Thank you.